Right, sir.
Yeah. Assalamu alaikum, everyone. Thank you very much for attending this webinar. I could see a lot of people attending this webinar. I see the weather is pretty good, and still you have find some time to attend this. I'll tell you why this seminar was important. Um, My name is Dr. Hussam Bawa. I'm a psychiatrist with a special interest in geriatric psychiatrist. I have worked in acute care and long-term care. I have seen a lot of people, especially from our own community, when they they are asked about personal directive, goal of care, facing, they face this question with a lot of difficulties, and their families, when they're under the probate, this whole process is very difficult for them. Seeing this, I thought probably we should do some educational activities for our own community. With this, I started talking in our home in the kitchen table. Luckily, my two sons are involved in law and also in estate planning and wealth planning. Then we started talking to Sheikh Fayaz, whom I have known him when he was a teenager. He's also just like my son, Faraz and Unaiz. So we have been working on these issues since last 5 years. We have ironed out some wrinkles, but still there are some which we are working on it. And it's mainly about the complication of Sharia side and the finance or distribution of the state in Canada. Those are the issues which we are trying to find the actual um, answer from the muftis, and we will continue to work on that. On some issues, we have come to some conclusion. Um, with this, I'm going to start on my topic. I'll first share what should be in the will. When we talk about what should be in the will, most of the people think that distribution of asset or estate, that who should get what. But I think will is more than that. And what should be in the will is the number one, personal directive. Number two, goal of care. So goal of care, it means when you're in the terminal stage of life, whether due to illness or due to your age, then you have to decide whether you want to be on life support machine or not. That is what the goal of care. You decide this with your family member and your service provider or your doctors. Now, if you're 65 or you go for annual physical examination, your family physician will give you a green sleeve where these two documents, personal directive and goal of care paper, should be there, and they should discuss. This all services are covered under Alberta Health Services. Another important paper in the will should be the distribution of estate. That's where the Islamic will come, and Sheikh Fayaz will explain more, and Faraz. Um, Beside will, I think there's another concept is hiba, which means gift. You can gift while you're alive to some to your children or to your family member. Now, some people, they write down very clearly about burial instruction. That is also part of will. And burial instruction includes, say if you are in a different country and when you passed away, what is your will? Whether your body should be buried closest place, closest graveyard, or it should come back to your place of origin. These are the things which, if you want, you can write down, and Sheikh Fayaz will give you more um, information on that. Then last is the any specific instruction. This specific instruction could be also on Sadqa Jariya. So these should be in your will. Now I'll briefly talk about personal directive. Personal directive, it is a legal document as per the Alberta Personal Directive Act. Who can do that? Any person who is 18 years and above can do the personal directive. And actually, as a matter of fact, they should do personal directive, enduring power of attorney, will, these three documents, they can easily do that. What it involves, personal directive, it's very easy. You can print personal directive form from website, Google personal directive form Alberta. It is a 4-page document where you have to write down your name, and then if you have done your personal directive before, then you have to revoke the previous personal directive. Then you write down about who should be the person, and that person is called agent, who will take care of your personal care and other care, excluding financial care, financial matters. So there are 8 or 9 domains where you just initial. Your agent could be one person or two. If you decide that agent should not be from your family, then you can choose that. And in some situation, I have advised and I have seen people from outside the family or from the government. In that case, there is a special office from the government called Last Resort Office, and Last Resort Office have a bunch of the trained social worker. They become the agent. Or you can choose the service provider, like doctors, who can act as an agent. There are 3 options given on that form. Last is that any other, for example, if you have a minor, you could choose that who would be the guardian for your children. And last column in this form is for any other. For example, if you have got a pet, then you can choose that who will look after your pet. So this is personal directive. After signing this personal directive, you need to witness it. And witness could be any person, but not directly related to agent. And that completes your personal directive. If you want, you can register. This registration is online. Where do you register? It is in the guardian office. What is the value of the registration? Only the name of the agent will go to the Alberta registry, not your full personal directive. Where you should keep the personal directive, give it to your family doctor, other healthcare provider. For example, if you are attending another chronic disease clinic, you give a copy to them. You give copy to your banker or accountant and lawyer. So that completes your personal directive. And I hope after this, you would be able to complete at least this personal directive. Now, Cory is going to explain more about enduring power of attorney and other matters. Now I'm going to pass it to Sheikh Fayaz Tilly, who is very well known to all of us. He is clergy or imam at Muslim Council. He will talk about the will and hiba gift.
Thank you. Fayaz, Sheikh Fayaz, over to you now. If you have any slides to present, you can go ahead and do that. Sheikh Fayaz, you're on mute. Looks to me.
While Sheikh Fayaz is coming, Brother Zulfiqar Agha has a very brief presentation. Why not we just ask Zulfiqar Agha to come?
Fayaz, yeah, just a second. Fayaz, sir. Yes, sir. Assalamu alaikum. You cannot? Oh, you have to be panelist, yeah. Yeah, he's just doing that. Just a second. Yeah, he's panelist. Now you're there. Please go ahead. Yeah. Let him do that.
Assalamu alaikum.
Yeah, Fayaz.
Wa alaikum assalam.
Wa alaikum assalam.
Can you guys hear me loud and clear and see me as well? Assalamu alaikum.
Assalamu alaikum. Yep, we can hear and see you just fine.
Okay, perfect. Thank you, Faraz. How you doing?
Alhamdulillah, bro. Alhamdulillah. How about you?
Alhamdulillah, I'm doing well. Dr. Saab, can I start, inshallah?
Sure, yeah.
All right. Bismillah ar-Rahman ar-Rahim. Alhamdulillah Rabbil Alameen. Wa salatu wa salamu ala Sayyid al-Mursaleen. Wa ala alihi wa sahbihi ajma'een. We begin in the name of Allah subhanahu wa ta'ala, the most gracious, the especially and the entirely merciful, the all and the eternally loving, the one who has decreed death and the one who has decreed life, and the one, subhanAllah, who has given enough for human need but not human greed. And may benediction be showered upon Rasulullah sallallahu alaihi wasallam, upon his companions, and upon all of you and your families, and upon our world as well. First and foremost, Ramadan Kareem and Mubarak to you and your loved ones. And I think really the month of Ramadan is a time to focus on the hereafter, and to get our priorities straight. And among setting our priorities straight, those action items would require us to prepare a will, which is not only congruent with the law of the land that we're living in, but also complementing or in consistency with the recommendation of Allah subhanahu wa ta'ala and his messenger sallallahu alaihi wasallam. Why is this topic important? It's so important because the time or place when a person will pass away, nobody knows. And that's why Allah subhanahu wa ta'ala, he says that it is not for a person to pass away except with the permission of Allah subhanahu wa ta'ala at an appointed time and at an appointed place as well. As a Muslim, it is our duty, your duty, my duty, our duty to fulfill the rights of other people. And our immediate family, our heirs, they have a right over us. And among these rights is the right of inheritance, which would lead to the preparation of a will. Now, as far as the heirs are concerned, and the direct heirs would be one's parents, one's children, and one's spouse, Allah subhanahu wa ta'ala has already determined and allocated their portion. However, there's a hadith wherein Rasulullah sallallahu alaihi wasallam said that it is the duty of a Muslim who has something which is to be given as a bequest, not to have it for 2 nights without having one's will written down regarding it. So as far as end of life care is concerned, advanced directives, where you want to be buried, all of these things should be mentioned and clarified in one's will as well. We are not going to get into the juridical reasoning and arguments with respect to what is the ruling of transferring the corpse of a body from one city to another. We're not going to get into the detailed discussion about the fiqh or the science or jurisprudence of giving gifts as well. But inshallah, we're going to establish a framework through which, the conversation will definitely continue. Now, as I mentioned before, a couple of points, inshallah. The first point is the Quran already mentions in detail the proportion of a person's wealth, which must go to the respective relations. And we cannot change that. For example, I cannot say that, my mother will receive more than my children, right? That is something which goes against Islamic law. Our children will receive more than our mothers, because that is the allocated portion that Allah subhanahu wa ta'ala has allocated for them. There are also many ahadith which state the importance of preparing our wills. And theoretically, and that's why I want to really, commend and applaud Dr. Bawa and our respective panelists for making out the time on this last beautiful weekend before, subhanAllah, the month of change and Ramadan actually comes in. Theoretically, if our wealth was easily identifiable and we lived in a country where it would automatically be distributed according to Islamic law, then we could be fairly confident that our estate would be divided correctly. However, the truth of the matter is that many of us have wealth, which is not common knowledge. For example, we might have multiple properties, different bank accounts and investments, shared accounts, right? We may have properties elsewhere as well in a different country. And as well as having our own assets, many people nowadays also have mortgages, loans from banks, loans from people which aren't common knowledge. Many people, subhanAllah, in our community have also given money as qard hasana, an interest-free loan for a good cause as well. So, a few points to consider is, number one, if we don't leave a will behind, the inheritance laws of this land may not be able to distribute one's wealth according to Islamic law. The second point is not leaving a will can definitely lead to internal family disputes during the distribution of wealth. But even prior to that, say for example, if one passes away in, let's say, northern Canada. Now, if the deceased wrote, in one's will that I would like to be buried near the closest Muslim cemetery, then that dispute would be avoided altogether, right? Islam has also set fixed proportions of a person's wealth for certain relatives after they pass away, and we cannot change that. One important thing is, say for example, we know that a spouse will inherit, right? A spouse is a lawful heir according to Islam. A person cannot bequeath extra wealth to one spouse, because there is a hadith where the Prophet ﷺ said, فَلَا وَصِيَّةَ لِوَارِثٍ, that a person is not allowed to bequeath, 1/3 of one's wealth to a person who is already going to be inheriting or who is already an appointed heir. We also learn, from Islamic law that one can use up to 1/3 of one's wealth, of one's estate, to distribute as one wishes, as long as it is not going to an heir. And the rest of one's wealth from the estate will be divided according to Islamic law. So what do we do? What do we need to do next? Just a couple of points, inshallah. We need to work out the total value of one's estate, which includes properties, cash, gold, all assets, however minute they may be, under one's sole ownership. Another question is, say for example, you own a home with your spouse. It has to be made clear who owns what percentage of that particular home. So say for example, if the husband owes 50%, and if the wife owns 50%, then if the husband passes away, only 50% of the equity of the home would be divided as per this person's will and Islamic law. Okay? And then, among other points, the last point I'd like to mention before we get into the hiba, or the gifting of one's wealth and estate in one's lifetime, is it is imperative and essential that a member of the family knows about all of your finances, direct debits, standing orders, and bills which need to be paid regularly. from which accounts they need to get paid as well. This will ensure there is no added pressure on the family if you pass away and they are unaware of the household's finances. So just quickly now, as far as giving gifts to one's children is concerned, and definitely, mashallah, our expert panelists, Cory, Unaiz, Faraz, Dr. Bawa, and whoever else is on the panel, they will get into, what is the best way to save as far as taxation or tax implications is concerned. But as far as an Islamic perspective is concerned, say, for example, there are parents and they want to give a gift to one of their children, but deprive the other children. This would be prohibitively disliked, makruh tahrimi, where the parents intend to harm and avoid giving the rights to the children. This would be prohibitively disliked. Okay? However, where the parents do not intend to harm children or bar a child from receiving, part of their estate or his inheritance or her inheritance, if that intention is not there, and if there is no valid reason of preferring one child over the other, this would also be considered somewhat disliked. However, say, for example, there is a child who is studying, for example, and this person has, hundreds of thousands of dollars in debt. If all of the heirs would come together in a meeting, and if they say, look, Dad, Mom, we're okay with you giving our brother or our sister a gift to remedy their student loans, and if everyone agrees to that, it would be fine. One has to realize is that all of our children have to be treated equally. Our Prophet ﷺ also said, وَعْدِلُوا اتَّقُوا اللَّهَ, have taqwa of Allah, وَعْدِلُوا فِي أَوْلَادِكُمْ, and be just and be fair with all of your children. However, all children will be different. Everyone's situation will be different as well. And if parents want to speak to all of their children and say, look, we want to give, your brother or sister a gift so they can move on with their life, and if everyone is in agreement with that, then there would be no blame upon the parents in this particular situation. And the last thing I'd like to mention is the legal definition of hiba means the giving away of such a thing from which the receiver can draw benefits. And how does hiba take place according to Islamic law? Hanafi jurists, analyzing gift contract on the basis of its analogy with sale contract, hold the offer and acceptance as its main pillars. So say, for example, a person tells their daughter, I have gifted you $100,000. And the daughter says, I have accepted that particular gift, then the hiba would be valid. Some other scholars, they say possession is also a condition. This is not an agreed upon condition, but in this particular situation, you know what, I could understand why this third condition is important, because the moment a person receives the $100,000 in their possession, then this would mitigate or curb or curtail or eradicate any disagreement with the rest of one's heirs. And subhanAllah, other scholars, they've excluded actually acceptance from the pillars of gift contract, assuming actualization of the gift contract by the offer itself. So this is also an interesting conversation, and maybe, we'll get our MCs to clarify it. So some scholars say, look, there's an offer of a gift, and as long as there's a verbal acceptance of the gift, the hiba is done. Other scholars say, no, there is a third pillar, and that is you have to get possession of the gift. Or, for example, your name has to be on the title of the home, if you're gifting a home. Other scholars have said, no, the moment you've given a gift, then upon the offer, we already assume that the person who is receiving the gift has already accepted the gift. And this is where obviously we'd have to clarify that in the last, or in the will of the deceased, what he actually meant by that, etc., etc. That's the basic framework. I know I'm over time, and I'll give it back to our MC. Jazakumullahu khairan.
Shukran. Thank you, Fayaz bhai. Really appreciate that. And now with this one, we will pass it over to Brother Faraz, who is going to take us to the legal implication of the will, and where can we go from there. Just a second. Yeah, I'm always running into this. Just a second. Okay. I think that's our okay. Faraz, can you take it up now?
Sure, I can start. Assalamu alaikum, everybody. My name is Faraz Bawa. I'm a lawyer at Stewart Sharma Harshani. As Dad, Dr. Bawa noted prior, there was a topic once upon a time about the various issues in Islamic wills. Shaykh Fayaz has also discussed this with me, and he's indulged my many laborious questions on the topic over the years. This is a task that we've been trying to solve, and there are definitely some complications, places where Islamic wills and Alberta's laws, and generally Canada's laws, will not fit. And that's where you have to try to think about what steps you want to take to get around that, or if you can get around that. The biggest problem that we see is that dependent relief, there's something called dependent relief legislation, which will usually say you must leave your dependents a certain portion of money. It has to be, it's not really a mathematical formula. It's not a black and white amount. Like other areas of law, like say for child support, for example, there's usually a black and white amount that you have to do. For leaving money for your dependents, it's a bit more of a gray area that depends on the size of your estate. More. And it's not as easy to predict. And where this becomes sometimes problematic is, and I stand to be corrected by Sheikh Fayaz if I'm incorrect in this, but a spouse in a family that has children will only leave, will receive, 1/8, or to my knowledge, that would be 12.5% of an estate. One way to get around that is something Sheikh Fayaz discussed, which was, giving a gift. And if you do it while you're alive, then it's not really an issue for the will because you've done it while you were living. But leaving 12.5% of your estate to your dependent spouse, that may become problematic for a court. In Alberta, we actually have not seen a test case to see which way it would go. Myself and a few other colleagues of mine have been working on this for a couple of years at least, actually now. And we're hoping to roll out a service where we're able to accommodate this. We're hoping to get that done in the next week or two during Ramadan. In that service, we'll have people that speak Arabic, Urdu, we'll have male lawyers, female lawyers, so everybody has somebody they're comfortable with. And this way we can do what we can for Islamic wills in Alberta. But that is the first issue, which is the distribution of assets for married people with children, not leaving enough for their spouse. That's definitely one of the major complications we're seeing. Later on, that can become a problem in how your estate gets finally divided, and if a judge will let the assets transfer the way you want or not. So there's an interesting question there, and we've come up with some solutions which we're very close to being able to roll out now. The other issue that we see coming up will be that Islamic wills are based on set percentages based on your family composition. Now, as your family composition changes, it's possible that the portions of your will change. There was some discussion and thought we had about, kind of future proofing your will and saying that if my family composition changes by XYZ, then this is the corresponding change I would like in my will. The problem there is that some changes that would arise give different percentages which appear to be based on gender. That later on, if challenged, could become problematic. So one of the other things that you'd have to bear in mind if you're going for the Islamic will is that you would likely need to update it or change it when your family composition changes, if any of the if any of the changes in your family are people who would or would not would be getting a portion of the estate. So that part's always something that you discuss with the Shaikh or an Imam. Lawyers and accountants will be happy to help you on other parts, but the Imam is who you want to go to for the actual spiritual advice and fiqh on this. They will then be able to tell you which changes matter or not. The program that myself and some colleagues are planning on rolling out will be done with the assistance of imams in Calgary, so we should have that covered. But yeah, those are the two issues that are the bigger complications in Islamic wills. Some lawyers in Ontario have done Islamic wills, and their solution to the 12.5% problem has been to use the wasiya that Sheikh Fayaz mentioned, the 1/3 discretionary portion, and use that to increase through various different ways the dependent spouse's 12.5%. And again, this becomes a religious legal argument, not a not a Canadian legal argument, if you will. But my understanding is that if you have a sort of legislated portion, if you've already got a percentage given, you can't go and bump that percentage up through other means. So yeah, there are lawyers that will say that they can do it. Whether or not that tactic works, legally it may or may not. I mean, the amount definitely helps. Spiritually, whether it does or does not, that'd be something to discuss with your imam. But yeah, those are the two bigger problems we're seeing with Islamic wills. Like my colleagues and I have tried to find a way to make it work with Alberta's laws through various waivers and all the beneficiaries getting independent legal advice, and then seeing how an Alberta court will react to it. That's something that we hope to have ready in the next couple of weeks. So keep an eye out for that. And those are the big legal complications or difficulties we see with Sharia wills in Alberta. So subject to any questions, I'll pass it back on to Brother Omar.
Thank you. Okay.
Are we good to go? Okay, assalamu alaikum. From the banking point of things, I have seen people die without wills, and I've seen people with wills, and it makes a whole lot of difference between the two. The ones with a will, everything goes smoothly and gets distributed as it's defined. The ones without the will can get very complicated depending on the size of the estate. You know, people will start contesting and it can go into courts and can go on for months and months. So ideally, if people can have the will done, it will make things much better and smoother for everybody, all the heirs. Some of the things that can be done is keep an eye on your accounts. The individual accounts, they will go directly to estate. And the ones that are joint, depends if it's joint with the right of survivorship, then it will go to the survivor, the remaining account holder, they can continue to operate the account. And if it's not with joint with the right of survivorship, then it will become part of the state. And other things are, for example, some of our brothers or sisters who have businesses, again, if it's sole proprietor or contracting under sole proprietor, then it will become part of the state. And if it's incorporated, then depends on if you have any other directors listed on the company registry. If there are other directors, they can make the decision to continue to use operating the account. And as far as investments, same process goes with investments. Individual name investments will go directly to estate. And if you have RSPs or TFSAs, in those you have ability to assign beneficiary, so they can bypass the estate and go directly to beneficiaries. Those are some of the main things that you can keep an eye on. Some of the people, common question I get is a lot of times, well, I've given somebody a power of attorney on my accounts. That power of attorney only exists as long as the person who gave the power of attorney is alive. As soon as they pass, that power of attorney is no longer of any use. So, and if you have safety deposit boxes and all of that, same process goes as well. If it's with right of survivorship or not. So it's probably a good idea for everyone to make a list of all the assets you have, the bank accounts, safety deposit boxes, any investments. A lot of times people tend to have accounts in different institutions, multiple different banks. So it'll be very helpful if you get started with making a list of all the accounts you have and, mortgages or loans and all the things. It'll make it a lot easier to put the will together.
Thank you.
I think that covers it.
Okay. Thank you, Brother Zulfiqar. Really appreciate that. Now we are going to pass it to Unaiz Bawa, who's going to talk about the estate planning process, tax implication upon that, and estate administration process.
So actually, just going to quick change. Cory Chan is going to go ahead of me, and then I will go. So we'll just pass it on to Cory, and Cory, I'll bring up your slides shortly.
Perfect. Well, good afternoon, everyone, and thanks to Mr. Bawa, Dr. Bawa, and Unaiz and the team for organizing today's seminar and inviting me to speak. Just for everyone that doesn't know me, which is probably most, my name is Cory Chan. I'm a tax lawyer with Moody's Tax Law. I previously practiced tax as an accountant with Deloitte and practiced tax law at Denton's. Now I'm practicing tax at Moody's Tax Law, which is a small boutique tax firm. We work with a team of Canadian and US lawyers, and we specialize in cross-border tax work. We do work with our accounting firm as well, Moody's Private Client, who does cross-border tax and accounting. And that's just for us to offer an all under one roof service offering for anything that's tax related. So today, I guess I'll just be focusing mainly on the estate documents. I know there's other presenters that have already talked about the will, enduring power of attorney, and personal directive, but I think I'll just really quickly highlight the important parts of it. So, we can probably continue forward and then pass these slides. And perfect. So the wills. So essentially, if you just, again, high level overview, if you pass without a will, the immediate problems, right, are there's no one appointed to deal with your estate. So meaning there's no executor or administrator of the estate, and there's no formal written record of what you wanted to be done. So that's like how your assets are going to pass to the next generation and things like that. So there are legislation that sets out who can apply to be the administrator of your estate. And there's also rules that apply on the distributions of the estate in the event there is no will. And it kind of follows the family tree on the division of assets. And I know Unaiz will probably go through that, so I won't dive into that too much. So there's three ways to really make a will. The first one is that you can hire a lawyer, like myself or Faraz, to draft a will. You can purchase one of those do-it-yourself will kits, or you can write a will entirely in your own handwriting. So, and that's what we call a holograph will. And the holograph will it has to be in your own writing and signed and dated in order for it to be valid. So just some important points there. Some other additional notes. Well, you have to have capacity, meaning you have to be mentally there to know of the decisions that you're making in order to create a will. There can only be one original copy of the will. If you do write a holograph will and sign it, there can only be one. If you do a second copy, it will revoke the previous one. That's similar if you were to redraft a will with a lawyer. Usually we have a clause in there that will say it will revoke any previous wills. If you do purchase a do-it-yourself will kit, you should only sign one original and then mark the others copies. For tax purposes, you always want to avoid naming non-residents of Canada as an executor. And that's because if you have a non-resident executor, it could deem your entire estate upon your death to being a non-resident estate, which then has adverse tax consequences. So, administratively as well, there's always problems of having a non-resident. It's just difficult for them to sign the original documents and send it to the courts here to have the will probated. So just some considerations there. So a enduring power of attorney, as Dr. Bawa kind of had spoke about earlier, it's a written legal document that gives someone the right to act on your behalf in respect of anything that's financial related. So for instance, selling a piece of land or dealing with your bank accounts. When you're no longer having the capacity to make those decisions, the EPA is what gives the power to that individual to make those decisions on your behalf. So it can also be immediate, take immediate effect on signing, or it can take effect on when you become incapacitated or a future time that you set. Those we call a springing enduring power of attorney. So it just depends if a certain event occurs. So if you don't have an EPA, what happens? Well, if you don't have one, someone is going to have to apply to court and essentially become your trustee. And essentially, they're going to have to hire a lawyer, probably make a court application, which would incur additional costs and also could take a substantial amount of time just to get one in place. Just to give everyone, maybe a first-hand experience. Actually, on Friday night at 11:30, a friend of mine texted me just as a family emergency. One of her aunts who has terminal cancer took a turn for the worse, and on Friday she started to have lapses of time where she lost capacity. She didn't know where she was. So she panicked and texted me and asked if I could help her quickly draft a power of attorney and also for a personal directive, just to assist them going forward. And so yesterday I visited the individual that needed the power of attorney. at that point in time, she was bedridden. She had difficulty breathing. She kind of was there and understood what I was talking about, but at the end of the day, I couldn't sign it with her because I couldn't really be certain that she did have capacity. So right after this meeting, actually, I just got a text. It seems like she's in a better condition today. So I plan to stop by right after this presentation to see if we can execute this. But, these are the type of things that you don't want to be dealing with at the last minute and have your family panic, not knowing what to do, right? So just having these in order will just go a long way for helping your family members take care of you. So a EPA allows for the attorney to deal with buying and selling your real estate, filing your income taxes, using some of your assets for maintenance and living expenses, hiring accountants or lawyers, dealing with any investments, and also paying for costs under a personal directive. What they can't do is make a will or change a will for you. They can't make a new EPA. They can't make a new personal directive for you outlining what your personal decisions would want to be in the event of health-related decisions. And they also can't change the designated beneficiaries of any RSPs or insurance policies. So those are some of the things that you have to know as well. So what does it mean when, determining mental capacity? What exactly, does that entail? Well, at the minimum, it means that the individual must know what property and the approximate value that they have. So for instance, the individual that I'll be seeing later, again, I'll ask her, okay, do you know what you owned? Like, you have a house, RSPs, the approximate value on those. Those are the things that, we'll have to go through. They must be aware of obligations to people who depend on them. So like children or spouses, right? They must also know what authority they're giving to their attorney, so allowing them to deal with all financial related matters. And they must know that the attorney is required to account for the decisions they make about your financial affairs. So if any of your children, questions them on the expenses that they've been making, they have the right to essentially go to court to make the attorney to provide the accounting records and such on those expenses. So who can witness an EPA? Well, it has to be anyone above the age of 18 and who is mentally competent. It doesn't have to be a lawyer, and you and your witness just have to be present together and see each other sign in order for it to be valid. So if the witness believes that they don't have the capacity to sign and execute the EPA, then they shouldn't be signing off on it, right? Which is kind of the thing I did yesterday when I was there, and at that point in time, I couldn't make that determination just because she wasn't really able to speak and it was just having difficulty breathing. So people who cannot act as a witness includes anyone who's a minor, who's mentally incapacitated, and also it can't be the person being named as the attorney themselves or a spouse or their spouse. And it also can't be your spouse or common law partner. So here, Dr. Bawa already went through the personal directives. So, high level, again, it's just any decisions that relates to your health related matters. So for instance, moving you to whether if you want to be resuscitated or not in emergency situations, right? Or if you're in a vegetative state, whether if they're going to withhold treatment. These are the things that the personal directive would cover. So without a personal directive, in emergency situations, most likely it would be the attending physician who would make that decision if you didn't have a personal directive. And the attending physician would know what you would want, right? As they don't know, most likely wouldn't know who you are. So it's important to have a personal directive just to outline what in those situations you would want the attending physician to do. In non-emergency situations, a physician can't make healthcare decisions for you. So again, someone would have to make an application to the court to become your trustee. Most likely, again, hiring a lawyer, taking a lot of time, and most likely going to have some disagreements within the family on how to move forward with your treatment. So for signing a PD, you have to have capacity. And again, what does that mean? Well, it means that you at the minimum have to at least understand the kinds of personal matters over which you're giving power to. So the health related matters, right? You have to understand the authority you're giving away, whether the person you name as your agent is truly concerned with your well-being, that you need the person you're naming to make decisions for you. And as long as you're mentally capable, you can always revoke or cancel the PD. And you also have to know that there's always a chance that your agent could misuse or abuse their authority. So that's just a risk, right? So it's very important to know who you're giving the power to. So again, you don't need a lawyer to draft a PD, as Dr. Bawa said. You can simply go online to Law Depot or Law Contracts. The Alberta government has a free one, which I provided a link here. The lawyer doesn't need to witness a PD, but again, there are restrictions similar to the power of attorney, and these restrictions include, minors, anyone that doesn't have the mental capacity, the person who is the agent or their spouse or common law partner. It can't be your spouse or common law partner if you're the one making the PD. It can't be a person who signs it on your behalf, and this is just an exception that the law makes in the event you can't sign it physically, but you must still have mental capacity in order to sign it. So here, again, witnesses have to act in good faith and refuse to sign if there's questions of capacity. If you do prepare a personal directive, again, Dr. Bawa alluded to this, you got to make sure that people around you know where you're keeping the document, and also providing it to the physician and registering it with the corporate registries as well. So here, some resources. In this situation, actually today, it was very enlightening to learn a little bit more about Islamic law. And after hearing a little bit more about it today, I don't think your do-it-yourself will kits will suffice, or a holographic will. I think at this point you probably want to seek lawyers that have dealt with this area of law, like Faraz, just to help you make a valid will, because it does seem like there's a lot of nuances here that the Alberta legislation may not be able to recognize as well. So just some thoughts on it. The next few slides, just really briefly, the use of trusts. Actually, in hearing some of the things that needed to be dealt with, I think trusts might be actually a tool, useful estate planning tool for fulfilling some of the Islamic rules. So trusts are considered separate legal entities. So they file their own tax returns. When a person passes, the trust still exists. It's its own person, essentially. For tax purposes, every 21 years, there's a deemed disposition rule that has to be taken account for. But for the most part, if it's an individual that's later in age, I don't think the 21-year rule would have any application, especially if they're later in their 70s or 80s. There's certain tax advantages with using trusts, and it also helps maintain control for the person who's setting up the trust over their assets. There's certain testamentary trusts which can be set up, such as spousal trusts within the will, or a trust for children or grandchildren within the will. I'm not sure how that would play in with the Islamic law, but basically upon death, we can also use alter ego trusts to bypass probate. So in the event that there's some question of the validity of the will, we can put some assets into an alter ego trust, which, you know, on your passing, essentially, it's the trust deed that would dictate how the assets within the trust would be allocated out. And the great thing about using a trust is that it doesn't abide by the same rules that a will would abide by. There's essentially, if you have a trust deed that dictates the rules of the distribution of the assets, there wouldn't be a mechanism for the beneficiaries or anyone else to really contest over that distribution that's chosen by the person who set up the trust. So maybe this is a powerful tool to fulfill some of the goals and objectives on the estate planning side of things. The rest of these just deal with foreign assets. I won't go into them. You know, if you have U.S. property, essentially, or property that are in other foreign jurisdictions, I think the most important thing to think about is that, one, there's going to be a deemed disposition on death. So the CRA is going to say you've been deemed to have sold of all your assets in those foreign jurisdictions and reacquired them, and that will lead to a tax triggering event. And two, I would most likely request the client to have a will in those foreign jurisdictions to deal specifically with those properties, because it's a very cumbersome process to take a Canadian will and probate it in that foreign jurisdiction. In fact, like, if it's not within a Commonwealth country, it'd probably be most likely impossible for it to be upheld in those jurisdictions. So that was about it. The rest of these U.S. citizen and information reporting requirements is just for your information purposes, but I'll pass it on back to Unaiz.
Great, thanks, Cory. So, assalamu alaikum, everyone. I think most of you might know me, or at least know me by extension, being Dr. Bawa's other son. And if you bear with me a second, I'm going to just share my screen and discuss a couple of things around estate administration, estate taxation, and how that is something you want to plan for, how you might plan around that, etc. So can I just get a confirmation that you're seeing my intro slide from someone?
Yep.
All right, thanks. So I'm not really going to take too much time introducing myself, but I'm a practicing chartered accountant who's practiced in the area of tax and estate planning. Overall, I've been in practice for just about a decade now, and I currently reside in Edmonton. So I think every individual slide deck's had a disclaimer now, but I'll throw up my own disclaimer again that this is general advice. We're here providing you information. Everyone's situation is individual and unique to themselves. So get your own advice as it applies to your circumstances. So what's a will? This is something that I think, the lawyers have probably talked about already quite a bit. And I think even in the intro, some of the uncles mentioned, but basically it says what's going to go to whom. In Alberta, currently, you can actually impose certain conditions, and this is going to be within reason, and there are court cases that show this, where you can, again, impose these conditions, put in certain clauses, right? So in popular media, sometimes we see that in a movie, so-and-so person passed away, but there was a clause in their will that said, if you didn't complete medical school, you will not get any of my will or something, right? So that, for example, would be something that is not within reason, but there are some conditions within reason that can be upheld within your will within the province of Alberta. Most importantly, as Faraz and Cory both mentioned, wills do differ and estates do differ depending on your province. It's mostly provincially governed. There are some things, especially on the tax side, that are more federal though. How often should you update your will? Basically, the advice that we give clients is you want to do this every 5 to 10 years, but also anytime you have a major life-changing event, whether that's getting married, having kids, getting divorced, or any big financial change, buying a business, selling your business, getting inheritance from other family members, whatever the case is. Anytime you have a big change, you wanna look towards updating your will. I will elaborate a little bit more on the common tips and traps around wills and estates, but having minor beneficiaries is one thing, and I think one uncle mentioned a question on that earlier, so I might round that out in a couple of slides here. And then the other one, which Cory did well to mention, is cross-border beneficiaries or executors. I'll elaborate on that a little bit later as well. So intestacy. So this is what happens if you die without a will. So what you're seeing here on the screen, these are the intestacy laws for Alberta, according to the Wills and Succession Acts. But this is not an exhaustive list. This is just kind of the basics that might apply to the majority of people. The actual intestacy rules are much more well defined than this. You know, what if there are no grandchildren and no spouse and all sorts of other things, right? But you can see here that if we keep in mind the fifth around how your estate should be divided that Fayaz went into earlier, and you see that, okay, that's how I want my estate to go, but you look at the intestacy rules here, you'll see that there's a problem. If you die without a will and these intestacy rules apply, your estate will be divided by the provincial circuit court, and it's going to be done in the order that you see on the screen. So basically, things are going to go either just to the spouse if there are minor children, maybe equally amongst the children, maybe equally amongst the spouse and children. So, I mean, you really want to have a will, basically, if you're trying to not run into these intestacy rules, which are not very clearly not Sharia compliant. So contesting the will, and, you know, Faraz talked a little bit about this as well. But, you know, why are wills contested? How can you contest them? And what obligation does the testator, so the person who's dying that has the assets, what obligation do they have? So, you know, in Western society, and again, like Fayaz said, and like I think everyone said, we're not going to debate about what's fair and why things are the way they are. It's prescribed to us as Muslims, and we're following that. But in the Western society, fair would mean equal shares to all children, and maybe more to a spouse and remaining to the children, or whatever the case is. So in Alberta, is a will legally required to be fair in accordance with that Western framework? Do we need to divide it equally? Well, no, we don't. In Alberta, a testator, again, the person that has the assets and is dying, can actually distribute these things throughout their will as they like. They're free to decide. That is for now. So like Faraz mentioned, in Alberta, there's no case that's been contested that's going to give us precedence on this. But again, the Alberta laws state that a testator can distribute their assets however they like. But for example, in British Columbia, there's currently ongoing a case with a Sikh family. And the Sikh family, I don't exactly know what the family dynamics were, but basically all of the estate went to the son and nothing to the two daughters upon both parents passing. And in that case, the two daughters, they actually contested the will. And they contested it without having any of these four grounds for contestment met. They did not contest the validity. They did not contest lack of mental capacity. They didn't say that the father was under undue influence, and they were not dependents. All of the kids are above 18. But they were still able to contest the will and get some portion of the estate. They didn't get equal shares, but they were able to get a portion from the estate. And the son still had the majority, but they were able to get something. And this is contrary to the written laws and contrary to any previous case, but this was awarded. So anyway, if anyone's interested to know more about that case, you can always chat with any of the lawyers or myself, and we can talk about what that looks like. And right now, that's just gone, it's gone to the BC Supreme Court. It hasn't gone to appeals yet, and who knows, maybe it will, and this is a relatively recent case. So, sorry, a bit of a long-winded way to say that in Alberta, again, right now, the testator can give their assets how they want, but we don't know how long that'll last, and we don't know, even if we have that assumption right now, what the contestment might look like. Now, generally speaking, if you are contesting a will, you have to claim lack of mental capacity when the will was made. You can contest again on the validity of the will. So again, if it was a holograph will, which Cory mentioned, where you write it in your own handwriting, that is legally viable. But if, let's say, I dictate my will to my wife and it's in her handwriting, the will's invalid, right? Or if I can't write my will, but my wife records me on my deathbed, that's invalid, right? Undue influence is another one. And also, if a will rules out for dependent support, then the court could rule against that. In Alberta, even once probate has been granted, contestments to the will can be made. This term probate we all hear about lots, and I'm going to get into exactly what that is and why that's important. So after the fact, once someone's passed away, what are we doing? So this process of estate administration is largely carried out by the executor, and an executor can engage a lawyer or accountant or other types of estate consultants to help with this, but of course that costs money. The executor is you're generally going to name the executor in your will, but if you only have one executor name, what happens if that executor predeceases you? So that's why you need to name a contingent executor and likely also a secondary contingent executor. So that way, even if these people that are supposed to be, the executor, they predecease you, you have another executor. And always inform your executor that, hey, you're my executor, or hey, you're my contingent executor, right? So who really cares about all this estate administration stuff? The beneficiaries care because they're getting the assets from the estate. But who really cares is the CRA, because there's a lot of tax around this, which we'll talk about. And the person that is individually liable, wholly liable for this is in fact the executor. And the executor has to do a couple of things, like getting clearance certificates. That's a technical thing, but I can elaborate on that in a couple of slides. The executor is the one responsible for getting that and managing that. So the CRA cares, therefore the executor cares, and of course we know the bennies care. Cross-border considerations. So non-residents, if you have a non-resident beneficiary, they're going to potentially have to pay more tax than they would if they were a Canadian resident beneficiary. And if you have a non-resident executor, that makes it a non-resident trust, like Cory had said, and that means that there's going to be other layers of withholding tax and probably additional filings as well for your tax purposes. So once someone's passed away, what are you doing here? Well, you as the executor have roles and responsibilities. You're going to be basically obtaining the death certificate, obtaining any documents that substantiate you're the executor, what's happened. So again, like Cory mentioned, you want to have your will in a place where people know where it is. You want to have it maybe registered corporately at a registry. As the executor, you're probably going to help planning the funeral, notifying the beneficiaries that, hey, you've been named in the will as a beneficiary. I'm going to be dealing with it as the executor, and you can expect your amount of the payout at so-and-so time once so-and-so matters are dealt with. As the executor, you really want to have an understanding of the assets, any debt that's outstanding, any life insurance policies that are outstanding on the deceased individual. And I'm going to go into, towards the end of my session, I'm going to go into exactly what we can do, each of us on a personal level, to really help our executors and even our family members with understanding the spread of assets. Lastly, one thing which is more administrative than anything, but I see so many times that executors struggle with this, is updating authorizations. So banks, general insurance, so that's insurance for your car and your home, sometimes mortgages, those kinds of things can be challenging for an executor to deal with. But again, if you have the will that shows you the executor, if you've applied for the probate process and you have a probate application from the provincial government, then the banks and the insurance agencies and whoever else will be easier to deal with. On the debt side and on the mortgage side, like depending on the debt that someone has at the time of passing, you need to understand, is any of that debt something that's going to be called? Is the bank going to say, oh, well, Unaiz Bawa, he had a house and he died, and we don't know who's getting the house, but us as the bank, we want the remaining $300,000 of his mortgage. So you have to pay, his estate has to pay that mortgage within the next 90 days or 180 days or whatever, right? And sometimes the banks will come and say those things initially, but typically as long as it's a clean estate, like Zulfiqar mentioned, at the top, that when an estate's well organized and well planned, these things don't happen. As long as it's pretty clean that way, a bank is going to be able to extend those timeframes for you potentially. So after the death has happened, you find out you're the executor, you've got the ball rolling, what happens now? Now is this probate thing. So probate, what it really is basically like a government certification of your will. The government's looked at the will, they've looked at the schedule of assets and said, okay, all of this makes sense. You you're saying you're the executor, you indeed are the executor. These are the assets you're in charge of. Now go and take care of your estate. So is it necessary to get a grant of probate? Well, it's not necessary. But typically people will get it. And I think Zulfiqar, he mentioned earlier that typically any bank isn't going to release assets without probate. And in my experience, I'll tell you that there are very, very few banks or financial institutions that will even consider dealing with an executor without some step or some stage of probate. By law, if your estate is under $25,000, you do not need to get probate, but again, typically you're going to. And even if you just look at someone's principal residence, you'll see that their estate will likely be over that $25,000 threshold. Do you need to use a lawyer to get probate? So using a lawyer or not using a lawyer, I know there was some commentary on this in the Q&A and comments as well. You don't need to use a lawyer for any part of what we're talking about here at all. You probably should use a lawyer for a lot of it if you can. For an application of probate, you don't need a lawyer, but I'll tell you, in the more complex estates, having a lawyer and an accountant walk through the estate administration process is very helpful. It's something that I've done dozens of times, and thankfully I don't find myself doing it as much now. Now I do more planning ahead of time rather than the administration after. But and while these notes are all great for anyone who's going to be an executor in someone's will, you definitely want to try and engage a lawyer if you can. The probate does need to be granted to the CRA as well as any other tax bodies. Again, if we're talking anything non-resident or cross-border, that'll likely be required. And a lot of times we talk about avoiding probate fees. Thankfully in Alberta, our probate fees are limited to a maximum of $525. And that's if your estate assets are over $250,000. If you have less than that, it'll actually be less than the $525. Compare this to Ontario, where it's actually, I think, 1.5% of your estate. So if you have a reasonably substantial estate, that's quite a bit that goes as probate fees to the government, basically. So there are probate fees, but they're limited in Alberta. So now that we've got the probate in, we've also got to deal with this terminal tax filing. So what this is basically, I'll start by saying that the general taxation upon death varies in different countries. And in some countries, we have what's called an estate tax. Some countries have a gift tax. We don't outwardly have an estate tax or a gift tax in Canada. What we have, like Cory had mentioned, is a deemed disposition of all of your assets upon your death. So the minute before you die, you're deemed to have sold all of your assets. So if I bought a portfolio of investments for $200,000 and now it's worth $500,000, the minute before I die, I'm deemed to have sold it to myself and bought it back by my estate. And when that happens, there's going to be a $300,000 capital gain there, which is going to be subject to tax. So that's the biggest income inclusion we plan around when we're talking about terminal personal tax filings. There are other income inclusions that happen when you have your terminal personal tax filing, and there is some other planning that you would do upon your terminal tax filing. Again, that's going to be very situation dependent. I won't get into the details here, but if you have questions, you guys can always get in touch with me, the other panelists, or the volunteers that set this up. Like Cory had mentioned, an estate is actually in legal form a trust, and a trust is its own legal entity. So upon the death of an individual, that new legal entity, the trust, is created. I've got in brackets there the initials GRE, which means graduated rate estate. That's a specific type of estate which is created now with the new laws. So before, our estates were a different type of estate. Now they're this GRE thing. So why am I saying this GRA thing? Why am I trying to educate you guys on some nonsensical technical jargon? Well, why it's important is because that new entity that's created, that is actually subject to the same personal tax rates that any individual would be. At least for the first 3 years, that's the case. After that, they'll be subject to the highest tax rate. So having the planning done within the first 3 years and having the assets flown out can be pretty important. Like I said, trusts are their own legal entity. They have their own tax filings to submit. That's 90 days after the year end. And typically your year ends December 31st, but it just depends on a couple of different things. If there's income earned within the trust, that is generally going to be taxed to the trust unless it's distributed out to the beneficiaries. And you can do that, but as an executor, you probably want to take some time before you distribute things out to the beneficiaries. So in addition to income being flown out to the beneficiaries, you can also have the asset itself distributed out to the beneficiary. But again, if you do this too soon, you'll remember I said that the executor is the one that's legally on the hook for anything that goes wrong or is outstanding with the estate. So you probably don't want to do it too soon. And like Cory mentioned, every 21 years, an estate is deemed to have disposed of its assets, and there's a taxable event that happens. So typically, most estate trusts, I should say, are going to be wrapped up definitely within 21 years, if not sooner. So yeah, once you've gone through a couple of these these tax filings as a terminal tax filing, as an estate tax filing, you want to make sure that they're current. You don't have any amounts outstanding to any individuals to any tax authorities. That's when this clearance certificate can be granted. A clearance certificate is very important. Again, this is something that the CRA is going to issue to you, the executor, and that will say that, okay, I'm free of any tax liability now. Now I can distribute the estate to the beneficiaries. And if there's anything that comes up afterwards with the CRA, I, as the executor, am no longer responsible. So if anyone is in the position of being an executor or might be an executor or is thinking of naming someone an executor, make sure that they're aware of this, this piece, especially if you won't be hiring an accountant or lawyer. Again, once you've got the clearance certificate, you'll make the capital distributions to the beneficiaries. The beneficiaries, that's like the legal term for your heirs, we can say, right? So whoever's getting the stuff that you left behind. And again, all of these things, the certificate of dissolution for your estate and all of that, these are all things that have to be sent to the CRA, have to be wound down with the surrogate court in the province and all of that. A couple of quick tips and traps around estates. So an executor, believe me, it's a very tiresome and thankless job, like so many of those kinds of jobs are. I haven't actually been an executor yet. I know I'm named as an executor in a number of wills, and I've done lots of estate administration working with executors, and that's where I bring my experience and speak to you on this. It's a tireless and thankless job, and an executor can be reimbursed for their expenses incurred, so mileage, parking, flights to see non-resident beneficiaries, whatever the case is, and they can even be reimbursed for their time spent. Now, if you're doing that, you're going to want to make sure that you have very good record keeping, because again, you don't want the beneficiary to think that you're charging an egregious amount or charging too much and taking advantage of your position as the executor. Whether we're talking about you as the testator, the person that is that has the assets and has died, or whether we're talking about you as the executor or whoever, you need to communicate early and often with your family members, with your executor. If you're the executor, with your beneficiaries. Open, clear communication at all times is always the best policy for anything, but especially in a matter like this, where we're dealing with the assets of someone that's no longer around, and we're trying to read into what their intent was. Fayaz mentioned, the concept of Heba, and that 1/3, a lot of times when I'm dealing with a Muslim client, we'll talk about naming a charity in your will. The best idea is to actually let the charity know ahead of time, because believe it or not, sometimes charities have specific criteria for receiving amounts through wills and all of that. And donating through your will, there are a couple of different ways of doing it. And in fact, there are some very tax advantageous ways of doing it, donating certain types of assets, and that type of thing. I know there was one comment in the Q&A box about insurance and takafful, and currently in Canada right now there really isn't too much for takafful, but with your traditional insurance product, if you structure it right, it can kind of mirror what takafful might be. So if you are doing that, then again, planning to do some donation with a piece of insurance through your will can be helpful as well. We also talked about gifting some of your estate while you're alive. That's a great idea. And in fact, I jokingly always tell people the best estate plan is to die broke. The day before you die, give away your assets, spend it all, go travel the world, go on Hajj, do all of that great stuff, spend your money. Unfortunately, it doesn't happen that way. And if you're going to gift some of your estate while you're alive, it's a great idea in theory, but there is a big tax implication on that. So in Canada, I mentioned before, there's no gift tax per se. So if I have $50,000 and I want to give that $50,000 to my son or my daughter, I can do that. And there's not going to be gift tax. They don't have to pay tax on the $50,000 I gave them. Now, depending on what they do with that money, if they take that money and invest it, the income earned on that investment, that might be attributable back to me, and I might have to pay the tax on it instead of them. There are other situations where maybe if I'm not gifting money to my son or daughter, let's say maybe I have a house and I want to give that house to them. Well, if that house has a capital gain on it, meaning to say that the house was purchased for $400,000, now it's worth $500,000, and the house has gone up in value, well, now that $100,000 that's gone up in value, there might be tax to pay on that. Now, I know this is something that, especially in our community, a lot of people do this and say, oh, it's no problem. We'll just say that we sold it for the same price we bought it. You can do that. You might get away with it as well. And if you get away with it, all the power to you. I've got no problem with that. But I'll tell you, I've run into a number of times where they try doing this, they get caught, and then I get the call from the client saying, can we straighten this out? Can you help us? And then we have to really get creative and see what we can do. So again, giving gifts are a great idea, but know what kind of gift you're giving, how you're doing it, why you're doing it, and what the implications are. Like Cory mentioned, planning with a trust is a great way to have a certain degree of control in one hand, but give the beneficial ownership or the benefit of certain assets to others. That's what a trust is for. We hear lots about trust planning for tax purposes, but honestly, a trust is originally conceived as a structure through which I can have control and the benefit can be derived by a larger group of people, my family or my kids or something. So if you have a company that you own, like a small numbered company or a professional corporation or something, or you have an existing trust, that can play a big role into your estate planning, and you can use it for your estate planning as well. But if you have that and you don't plan ahead with it, it'll just give you much more headache. Again, I went into the non-resident matters. If they're non-resident bennies, you'll have estate tax. If you have non-resident executors, it's a non-resident trust. When I say estate tax, again, in Canada, there's no estate tax. So if my estate is leaving behind $500,000 to my son doesn't have to pay tax on that $500,000. But depending on what that $500,000 is comprised of, if it's cash that's going to him, he pays no tax. But if there's if there's investments and the investment have gone up in value, that increase in value, that's where I'm going to have to pay the tax before it gets passed to him as a beneficiary or before it goes to my estate. But the reason why I bring that up again is because for a non-resident beneficiary that's in some other jurisdiction, there may actually be estate tax. So there are some jurisdictions in the world where the entire balance of your estate could be taxed, could be subject to tax. Maybe it's over a certain threshold like we see in the US, or maybe you just have to pay that the tax on that whole amount that you're getting. So I'm now going to quickly stop sharing this screen and quickly just show you a schedule of assets, something that I'd mentioned earlier. And I just want to quickly give you guys a look of what that can look like. This is a very basic one, but I just want to share it so you get an idea. So this, for example, could be what a schedule of assets should look like. So I think Zulfiqar mentioned this, and I'm sure a few other people have thought about this. I'm sure people have something like this, particularly because you can use this not only as a way to consolidate how and where your assets are, but you can also use it to maybe keep track of how much you're giving in zakat. But just a quick high-level overview of this, you're going to have a listing of what each of the assets are, like you see here on the left. You might have who is the legal owner on title, whether the husband owns it, whether the wife owns it, whether they own it jointly, maybe when it was purchased, maybe the original cost, and then the fair market value. And the reason why you want to have the original cost and the fair market value is because on some things, again, if there's an increase in the value, an accrual in that investment or in that asset, there may or may not be tax to pay on that, and it might be helpful to know that. Now, the real important piece here is what you put in your notes. So let's say if I were to pass away tomorrow and my wife, and she makes fun of me for this sometimes anyway, that, you know, and as you know where all the accounts are and this and that, so if you die tomorrow, what am I going to do? So I told her, you're going to go to this Excel spreadsheet and it's going to say every bank account we have, every mortgage we have, any type of asset, they're all listed somewhere in the spreadsheet, right? So we've got, for example, an RBC savings account. It's under, well, say, for example, my name. Currently, it holds 20,000 in cash. The purpose is that it's just our rainy day fund. They call it a contingency holding. And here's the account number, and it's accessible through any RBC. Let's say there's another type of asset that's going to have a different account number, a different place it's located, and maybe there's going to be an original cost versus the fair market value now. And again, when we look at listing out our assets, it helps anyone, executors, family members, know what is where, which is very important, again, through the probate process, through the estate administration process, and eventually through paying things out. And I'll tell you, as someone that's dealt with estate administration and as an accountant, if we have this type of document, it makes our job much easier, which means we charge much less to the estate. So anyhow, that's all I have to say now, and I'll pass it back to the hosts to field any questions. Thank you.
Yes, Unaiz, I think, can you just tell briefly about children or adult with disability? They can have their trust, and CRA will also put, or government will put some money in it, and the maximum amount is, I think, 60,000. A lot of the people, they don't claim this. One reason, they don't know. Second thing, even if they know, they don't want to say that they have disability. I think this is something which people should know.
Yeah, great idea, Dad. So, and unfortunately, this is another thing that I think comes out of our community more than anything. You know, and I can speak, I've got friends and other extended family members that have kids that maybe have autism or some other conditions, but because this planning where we can actually get a benefit for our kids, it's got the word disability in it, we shy away from it and we don't want to deal with it. But it's really not a great idea. If you have the ability to plan for that, you really should. So there are a couple of things to keep in mind. One is this thing called a RDSP, Registered Disability Savings Plan. It's just like an RESP or RRSP, but it's for the benefit of either a minor who's disabled that's in your care, or potentially even an adult dependent who is in your care. So someone over the age of 18, but they are deemed to be disabled and they're in someone else's care. There's this other thing called a registered, rather a disability trust, also known as a Henson trust. Now, a lot of times people say, well, I don't want to have a disability trust because if I have too many assets, then my disabled family member won't be able to get AISH or any of these other programs. Well, the beauty of the disability trust is you can have a disability trust and any assets held within the trust don't actually count towards saying that the disabled individual personally holds those assets. So meaning to say that that disabled individual can still get AISH, can still get these government support programs, because that disability trust, the assets held in there aren't considered to be belonging to the disabled individual. They belong to the trust, which is its own entity, and the trustee of that trust is managing it for the benefit of that disabled individual. Lastly, like Dad said, there are government bonds and government contributions towards an RDSP that are available under certain circumstances. So again, if you work with an accountant, if you work with a financial planner or a financial advisor or a lawyer, if you work with any of these types of people, go out and have the discussions with them. And if you don't know where to start, be in touch with any of us panelists from the board.
Yeah, and I just want to add one thing, that people who are on long-term disability, there is a disability tax credit, which you can get it, and that is not related to will or this. While we're talking about this, that's why I thought probably I'll mention it. And disability tax credit is not means tested, means whatever earning you have, that you can keep it, but still you can get this tax credit. So there are a lot of other things which I think people are asking, a lot of questions, but I just want to say that over the years when we were talking about will and tax implication, we have learned few things. One thing is about the spousal rollover. Spousal rollover, we could do it very easily in terms of pension, because there is no other choice. Pension is only for survivor spouse. So there's no discussion. I think every alim, mufti, everyone will agree. The issue comes, what about the spousal rollover for RRSP, spousal rollover for house? Generally, people have agreed to this, that spousal rollover should be okay for house or RSP, because you will save money. And the whole idea of will is that other half of your partner should have a better life. In that case, you can have a discussion with your children and write a will or amend the will that this should go to the spouse, and after the last, the spouse passes away, then it should be distributed as per the will. This is the amendment which I think a lot of people have done, and majority of the people and alim have partially agreed. I think Fayaz will give his more comment on that.
Fayaz bhai is gone.
Oh.
So Fayaz had to go. So
Okay, Sheikh Fayaz has to go, but I have discussed this, a lot of people, I think there is some agreement on this, what I have said.
And Dad, I'll quickly just, I should have mentioned in my slides earlier, but I think I got excited and wanted to get through everything. I talked about the tax upon death, but I didn't mention the spousal rollover. So to clarify just a little bit further, the spousal rollover is when, again, if someone dies, let's say there's me and my wife and we have some kids. If I die, my assets can go to my spouse tax-free. There's no tax implication. Like I said, if it wasn't going to my spouse, if it was going to someone else, then there are these deemed dispositions and various income inclusions, and you have tax to pay. If it just goes to my spouse, there's no tax to pay. In almost every circumstance, there's no tax to pay. And when then the spouse passes away, then the spouse is going to have to distribute the assets to the kids, and that's when there's going to be tax to pay. Another joke that I sometimes make is that we got to just make sure that this spouse marries another spouse, and you keep marrying down, and then you'll never have to worry about paying any tax, right? But anyway, that's what the spousal rollover is. But yeah, if depending on how you're distributing your assets, and if you're doing it from the get-go in the conventional Sharia will, the 1/8, 7/8 and all of that, then you're going to have to look into the tax implications maybe.
But there's a lot of questions.
Okay.
So there are a lot of questions, I think. I don't know, Faraz, Unaiz, and Cory has gone, I think.
Yeah, Cory had to leave. I saw a couple of questions, and there's one that I saw and I'd like to maybe speak specifically to, and then I don't know if Faraz, if you or Zulfiqar want to jump in with a couple of others, but there's one that says if a beneficiary designation in an RRSP or TFSA will override a will. And this is very interesting because typically we would see that, a will is going to override anything. But we recently had a case, and funnily enough, it came out of BC as well. This one went to the federal courts, though, and it was the Kalmuski family. And what happened was that there was a beneficiary designation made on an account, and it contravened what was in the will. And the court actually said that, no, you know what, this asset that has a Beni designation separate from the will, that is actually considered to be part of the whole estate. Because if they looked at the paper trail and the discussions that the father had with the son that got that one RRSP and said that, his intent wasn't there to actually just pass this to the son over and above what was going to come from the assets, the father meant for it to be as part of the whole estate. Now, of course, this went through a number of channels, it went through a number of courts, and, in speaking with some lawyers that we work with, like, I think this probably could be appealed, but in reality, it hasn't been appealed yet, and this decision is probably 5 or 6 months old at this point.
So are you going to post it on the Facebook? Yeah. So I think there were lots of interest in terms of looking at the presentation afterwards. We will be posting the recording on the YouTube and Facebook page. So kindly go in there in case you have missed out on some portion. There was one question, maybe I think, Unaiz, it is applicable to you. It's about can you make one of your adult children as an executor? And I think you did answer in your slides. You can, but not your spouse though, yeah?
Yeah, so no, actually you can make an adult child your executor, and you can certainly make your spouse an executor as well. So someone can be both an executor and a beneficiary. So trusts are very funny, interesting legal entities, and generally speaking, there are three parties subject to a trust. The person that creates the trust, known as the settlor, or the testator in the case of the type of trust we're talking about. There's the executor or trustee, and then the beneficiaries. No one person can be all three of these, but one person can be two of these. So our executor can be an executor and a Beni, and so on and so forth. So you can have a spouse or an adult child do that. One question that I saw come up in the Q&A that maybe I'll also answer was that what happens if we have both parents that are resident in Canada pass away, and then we have minor children that are left in Canada, and we don't want them to get all the money right away. We want to have it in trust managed by someone. So can we have an uncle or aunt from back home be the trustee or executor? So this goes back to what I mentioned in the slides. Yes, you can have a non-resident executor, but it will create quite a bit of problems for you, I think, from a tax standpoint. You can do it, but I would say weigh the cost and the benefit of having that family member be the non-resident executor, but needing an accountant and lawyer here in Canada to work with them to make sure everything's being managed, or just appointing someone else, a close family friend, or maybe even a lawyer in the community that you know and trust as the executor instead.
Okay, thank you. Dr. Bawa, any concluding remark?
Yeah, I saw one question earlier. It was for Sheikh Fayaz. And that question was that somebody was reading the will and asked about that 1/3 person can distribute the way person likes. I think this is true. And if you want to know more about will, the distribution of estate or asset, Surah Nisa has lot of details, exact details given in that, and you can read it, translation of tafsir. It is, you don't need to ask anyone, and you can read that, and exactly, I think you will get your answer. Now, there are a lot of questions about hiba or gift and will. So again, on YouTube, there are a lot of video. Mufti Zubair Ahmed's video is about 34 minutes. It's reasonably good. Dr. Israr Ahmed's video is about 8 minutes. It's really good, and content is really good. And Mufti Masood is about an hour. That also is highly recommended. we are running, short of time. There's a lot of questions. What we are going to do, that we will try to answer those questions, and we'll try to put on the website. Brother Omar, can we do that sometime later?
Yeah, we will go into that, and definitely, like, I do see lots of interest from the community and the members here. We will try to answer those questions as a FAQs, and we will not try to answer we will try to answer in a generic form rather than individual kind of conditions or situation there. And that's what we will do, and we will try to post those in on our Facebook page, while the recording will be played on YouTube and Facebook also.
And I don't know, is Faraz there, or Faraz, are you mute?
Yeah,
No, I'm here. Yep.
Yeah. So you have got also a list of lawyers. So can you display that, or?
I don't have the list in a written format, but we, as I mentioned in the presentation section, there is a group that we're working with to come up with a wraparound service for Islamic wills. The names are so far myself, Rami Katrib, Faisal Sayed, Ambreen Azim, and Rabi Ahmed. There are a few others that we're in touch with. We're just trying to finalize the group to figure out exactly who's going to be involved and to what extent. There's a plan in place that we'll have where imams, tax professionals, financial advisors will all be involved, so that people can come and sit down, work together with the group, and make sure that their will functions in a Sharia way, in a tax effective way. It manages their future assets as well for any financial planning, and that the steps that can be taken to make sure it's as compliant with Alberta law are taken as well. So that's something that we hope to roll out shortly, and I can provide the names and phone numbers and email addresses for the lawyers that we've discussed this with so far. There are a couple more that we're waiting to just hear back from. So once I have that, then we'll make a bit more of a formal announcement.
Yeah. Okay. Right. Okay. So we are going to close these sessions, but I must say that there's a lot of interest. We had roughly about 94, 95 people attending, and there was a lot of people on Facebook also, a lot of interest. Sheikh Fayaz also was very impressed. I must say one thing, that half of the people, including, lawyer and accountant and physicians, those are the people who have attended IANWC Weekend Islamic School, and they are a member of IANWC. So inshallah, we will try to compile the question, and we also try to compile a service for our members. Thank you very much for attending, and we will also post the recording of our video. Allah, I'll just make a dua that Allah make us, give us tawfiq to follow the Islamic principle while we are doing or writing the will. Ameen.
Shukran. Thank you, everyone. Now we will close this session. Thanks for joining us. Allah Hafiz.
Thank you.